Remember, mediation is non-binding. You'll hear about binding arbitration later on. This is the ADR Center stuff. This is the private mediation stuff. And I must say, when the ADR Center first opened, and I read that one of the cases that was being targeted was wrongful dismissal, I smiled and I realized somebody up there at Queen's Park has finally realized something useful. Wrongful dismissal initially was the only one that was targeted for such high involvement. Now it's more 80% of all the cases are going to ADR. But wrongful dismissal has sort of had its heart in mediation. It is a prime candidate for mediation. And now we're going to hear about why you want mediation, no matter what side you're on, and then how to do it, all in 45 minutes. And we have three distinguished speakers. You always say that even if they're not, but they are today. We have Mark Ellis from the firm of Castles, Brock & Blackwell, who, other than being a comedian, also practices exclusively in the area of employment law. He will give the management side viewpoint of mediation. Then next we have Linda Abrams from the firm of Torrey & Torrey. Linda must be the only plaintiff's counsel in Torrey, but she is presenting the proof that even large firms have consciences. Linda will be presenting the plaintiff's point of view on the mediation process. And then as the neutral, we have Deborah Sword. I just knew her as Deborah Sword. Deborah is not only a part-time mediator at the ADR Center, hired originally as the wrongful dismissal specialist, as I was told, also has a private mediation practice in which she does all sorts of disputes, and as well as doing mediation disputes in the private sector for wrongful dismissal cases, because I've personally used her. So we're going to start off with Linda, I think, right? Yes. Linda's going to tell us, from the plaintiff's point of view, all the good stuff about mediation.
Thanks, Barry. I've been asked to comment briefly and in general terms as to why, from the perspective of an employee who believes himself to have been wrongfully dismissed, mediation is a dispute resolution mechanism that merits serious consideration. Let me begin by exploring for a moment the mindset of the terminated employee. It's difficult for someone who hasn't been fired from a job to truly comprehend the sense of loss that accompanies termination. Some commentators have compared the loss of a job to the experience of divorce or a death in the family. Because work provides recognition and a sense of accomplishment, individual perceptions of self-worth and self-esteem are often derived from the achievement of professional success. Job loss is often experienced as a measure of professional and personal failure. The reaction of the terminated employee is often one of intense emotion. Typically, his or her anger, shame, sadness, self-pity, and fear, the amalgam of emotions that tend to be experienced, may pose substantial barriers to settlement. There is no question but that emotional issues can and do frustrate efforts at dispute resolution. We've all had clients refuse economically reasonable settlements that were not emotionally satisfying. We've all had clients who've said, it's not the money, it's the principle of the thing. The same clients often take the same deal or a worse deal, weeks, months, or years later when time and lawyers' fees wear them down. Mediation, in my view, is a good choice, and some would argue the best choice, of dispute resolution process when the barriers to settlement are largely emotional in nature. Mediation acknowledges that the psychological and emotional components of a dispute may be more decisive than the legal and factual ones. For the aggrieved employee, mediation is a cathartic process. It provides her with an opportunity to vent. By controlling communications between employee and employer, by keeping the two physically apart if necessary, and by acting as a kind of translator, the mediator can facilitate a discussion of the factors leading to the dispute and to the parties' inability to resolve the dispute on their own. Even without agreement being reached as to what actually happened, who was right or who was wrong, an attentive ear and sympathetic attitude on the part of the employer may go a long way in providing the employee with the validation that he craves and may break the negotiations impasse. In emotionally charged disputes, the litigation process may polarize the parties. The parties, through their counsel, take positions and make demands that tend to poison an already tainted relationship. The employee may see the employer's posturing as evidence of bad faith and heartlessness. Traditional bargaining tools, such as threats, bluff, and exaggeration, may exacerbate feelings of betrayal and outrage. As well, litigation counsel, anxious to be seen as vigorous and aggressive advocates who fight to win, may take a hard line in settlement negotiations that may not reflect the client's real needs and interests. Mediation short-circuits these problems by placing the power to settle the case directly in the hands of the employee, with the lawyer at her side to act as resource person. Mediation provides the employee with an opportunity to hear the employer's side directly, unfiltered by litigation counsel's advocacy, and with an opportunity to respond to the employer directly. The mediator's role is to enhance the communication between the parties and to encourage dialogue by paraphrasing, summarizing, and reframing what is said, by debunking assumptions, and by acknowledging emotion and the legitimacy of emotion. The mediator serves to ensure that the parties say what they mean and understand what is being said and why. Even intransigent parties tend to soften their stance when they hear the other side of the story and are gently prodded by the mediator to acknowledge the weaknesses in their own cases. Aggrieved employees typically want their day in court. As the employee's counsel, you should hasten to remind your client because the remedies available to a trial judge are limited in scope and nature, compromise solutions are often not possible. And while it is true that many cases settle without the intervention of a mediator, more often than not, settlement occurs at the 11th hour, when the parties have already expended large amounts of time, money, and effort, and much ill will has been engendered by the adversarial process. Mediation, on the other hand, is a dispute resolution process that encourages the parties to adopt a cooperative and creative approach to resolving their dispute in its early stages. Mediators create an atmosphere conducive to brainstorming for solutions that address and satisfy the parties' real needs and interests that are often belied by their actions and statements. Mediators are charged with the responsibility of facilitating the exploration of value-creating and cost-effective alternatives. And because mediators are bound to protect the confidentiality of each side's disclosures, in mediation, proposals can be considered without their authorship being uncovered. These proposals may reflect what the parties truly want, but are afraid to acknowledge on their own. In a paper presented at the Canadian Bar Association Continuing Legal Education Program in February of this year, Mr. Justice Adams of the Ontario Court General Division and Naomi Bussin, a law clerk, commented that what people want is to have their conflicts resolved, but not necessarily tried. Mediation provides the aggrieved employee with a dispute resolution mechanism which is in many ways similar to a day in court, which makes available to him a larger panoply of remedies at considerably less financial, temporal, and emotional cost. And if the mediation fails to achieve a settlement and the case must proceed to trial, all is not lost either. The observations that you as counsel make during the mediation process may prove invaluable in strategizing. You can assess the major strengths and vulnerabilities of your own witness or witnesses, as well as those of your adversary. You'll know the themes on which the other side is likely to rely, and you can structure your case to counter those themes effectively. Further, you can gauge from the mediator's reactions which of your opponent's arguments are likely to be most persuasive and respond accordingly. And even where mediation does achieve a settlement, there will undoubtedly be cases where you as counsel will be left feeling dissatisfied. You may leave the mediation session with a nagging feeling that you could have achieved a better result for your client had you tried the case or yourself negotiated the settlement. And in this regard, I would urge you to keep in mind that the dispute is your client's dispute. And if your client is satisfied with the way that his or her dispute has been resolved, if he or she thinks that the settlement that has been crafted by himself or herself is fair and meets his or her needs, then in my view, you can feel comfortable that you've ably served your client by referring the case to mediation.
Thank you. I feel like writing that out and using it at the beginning of every mediation as to what the purpose is behind it. That's very, very well put. See, she hardly mentioned money at all, but 2 or 3 hours into the mediation, money does come up.
Don't let him do it. He'll put it.
Money comes right out of the mouth of Mark Ellis, because his clients, although usually very caring and everything, also care about the bottom line. So how does the bottom line employer deal with this soft, touchy-feely plaintiff and their counsel in the mediation? And why do they want mediation?
First of all, I want to say that I did provide a paper today. It's out there and you can pick it up. The problem is that I thought Barry said FDR, so it won't be very valuable, my paper on ADR, because it's actually about American presidential history. But I'm still willing to give a little talk. I must say that when I first heard about ADR, I thought it was very Californian and very sort of neat, and we'd do that, but I didn't want to go at all. And I was there the first day they opened for the first session, and I think it's fair to say that I've had to grow with it just the way other people have had to grow with it. And wasn't I?
No, because you were with Janice, right? Because she always claimed to do the first one. Oh.
Okay, I was there the third day they opened. In any event, I must say that I thought that the process was going to be a very difficult one to sell to clients. And I think that's because basically once you're at that stage, it's because there's been litigation. And if there's been litigation, it's because the parties have sought off and said, look, we're going to have a fight about this, and it's going to be long-winded, and it's all about, the nature of legal ramifications and machinations, and we're in it for the big picture and for the long road. That's certainly true of most clients that I would act for if I'm acting for an employer. So the employer says, is this a good idea, to the employer lawyer? And frankly, I would have thought that the answer would be a knee-jerk reaction saying, no, it's not a very good idea. Because a lot of the very powerful tools for defendant lawyers in wrongful dismissal involve the process of litigation itself. I think you people know better than I do that the passage of time is disaffects the interest of the plaintiff very clearly. The expense of having litigation pursued on an ongoing basis in a non-contingency based fee structure like Ontario, very difficult to peddle. And the passage of time, the mitigation of damages problem for employees, that they must go out and seek to mitigate their damages. They must try to feed their children and all that other good stuff while they have a big fight with the IBMs of the world, make the litigation experience for the employee very difficult and not so problematic for the employer. Now, in fairness, the good thing about the mediation process is that the mediators and the plaintiff's counsel and those things make it poignantly clear to the representative of the employer how expensive it is for people like me to be engaged, which I think is a nasty low blow, frankly, but having said that, it works most of the time. It is equally, if not more expensive for the defendant lawyer to be paid than it is for the plaintiff lawyer, and sometimes the plaintiff lawyer may quite quietly take a $500 retainer and get paid at the end. That has happened. I think, George, has it happened? Once it happened. So the perspective from a defendant's position is in a entirely objective, without subjective assessment situation. I think probably the employer says, well, I'm not sure I want to show up at all. And remarkably, that's what every employer I've had to deal with has said from the get-go, notwithstanding some change in my perspective about how valuable the situation would be. A lot of the reason is because of that inertia that I've discussed fairly briefly: delay, expense, defenses that are possible that are better served in a court of law than being chatted about in open forum amongst the individuals. And then there's also the tactical issue of laying everything on the table in a confidential session, which can only be, in a limited sense, confidential because everybody has to, in essence, lay their cards on the table type of thing. However, I must say that coming from that stop-start on this and thinking that way about being disinclined either to go or sponsor going to clients, in every case I've been there, except for two, and I've been, I think, over 20 some odd times, the matter has settled. And it settles, what I appreciate about it is it settles with people starting as defendants saying, not interested. I'll go because there's a judge who will ultimately enforce the responsibility on my part to go. End up going, and gifted people like Deborah figure out a way to get the solutions hammered out. I guess if I was going to be discursive about this a little bit, instead of just giving a profile on the employer's situation, it strikes me as one of the most fundamental attributes of this system is that it's very, very cathartic. And it's not only cathartic for the employees, and those of you who have done it, or I'm sure most of you have, it's a chance for them to say their piece. And so once they've said their piece, the employee, they tend to sort of lay their cards on the table and their heart on their sleeve and all that, those other good expressions. And that seems to work very well for those persons to say to the employer face-to-face for the first opportunity they've had to do it, that this is the problem they have with what happened. Often, I think maybe Deborah would say that we hear that the employee says, I'm not really here for the money, which is an excellent point they make. I always take them up on that after. But they always say, I'm here for a lot for the money, but I'm mainly here because I really was wronged, and I want people to stand up and pay attention to that. The employers often say, gee, you know, when we huddle, they say, I didn't realize it was quite that intense. You know, this was a layoff of 500 people across the country. I'm surprised Sam really takes it to heart. But the fact that now Sam may know through the interaction of the parties in discussing it that in fact, look, Sam, it isn't anything personal, and we'd like to give you more money, but we have 499 people watching, may well have people going back to the table saying, well, maybe it's not as bad as I thought notionally. It's equally cathartic, I think, for employers because of two things. Number one, they get to know the basis of what that plaintiff is feeling and going to the press about. But more importantly, in terms of going to the next stage and talking to people about the termination process in the company, about avoiding problematic issues like potential punitive damages for, you know, what was voiced as the reason for termination and all those other good things, which added up to a lawsuit that may never have had to happen if things had been spin-doctored better. Very cathartic for the employer as well to get this process underway and understand it a little better. In my paper, I kind of tried to analyze what we end up always having on the blackboard by the end of the session, which is sort of the pluses and minuses that go both ways, that when you look at it subjectively and objectively, if the parties are really concentrating on getting the thing done and getting it over with, it's very compelling from both sides. But I guess what Deborah has said and others up there at the center have said to me, and I think it's very true of all matters, everybody leaves satisfied but very unhappy. And that's probably the same way they would have left court 3 years later because, and the lawyers would have made a lot more money, which is a very negative aspect for us. But professionally speaking, I must say that they leave saying, wow, we did a deal. It's not a perfect deal because I didn't really get what my want list was when I was on going in. But equally true, the other side had a very major want list that was up there on the board. And it, you know, 4 out of 5 of them are done, or 3 out of 5 of them are done, something like that. But the fact is that it gets done by consolidating the respective interests, the respective negative aspects of going forward in the litigation process, and the deal gets done or it doesn't. So I must say, from a standing start where I said, this is an awfully bad development, and I really don't like this system at all, I quite like going to ADR now to get the thing done. If it doesn't get done, there's always a chance to have litigation. The final thing I might say about it is that we all, I think, some of you did, and I know I heard it from some of you people and from people in my office, that this was literally going to kill employment law, this issue. Because, you know, we'd settle everything up within the first 4 weeks of litigation and then, you know, there'd be nothing to do. Well, we all know that hasn't come to pass, and in fact, it won't come to pass, so that's the good news. The corollary is that I really do think it's a very effective way to resolve issues that would otherwise go on for years and make nobody happy. So that's my spiel. That's my story. I'm sticking to it.
All right. Thank you. Now from the neutral, Deborah, tell us from the middle of the non-round conference table at the ADR Center.
Thank you. Janice, see me after. I'll give you a certificate saying that you were, in fact, the first. And I know because I was there, and it was my first at the ADR Center, too. How many people have been to the ADR Center? That's great. If you haven't received an invitation to come and be counsel yet, please feel free to drop by. The rooms, the physical layout tells a lot about the kinds of things that Linda and Mark just spoke about, how we try to make it a comfortable place to be. The breakout rooms, we've done quite a bit to make people try to be comfortable there in what can be a very tense situation. So it's at 77 Grenville, 8th floor. Please feel free to come by and say hello. Lawyers tell war stories, and I must say that mediators do too. But here's what I want to talk about. It's the difference that you hear when you hear mediators tell war stories. And how many of you have heard a mediator say, I settled it? But if it didn't settle, it's they didn't settle it, right? 'Cause, hey, it couldn't be my fault. Mediation isn't about blame, it's about shared responsibility. We need you. When I hear Mark talk about his conversion, it's Thank you, Mark. This is what we need, is for you to feel invested in the process, because we need you there. We need you to be fully and meaningfully participating in the process. You have a role to play. And I've written a paper on how to market your services as a lawyer, not as a mediator, but as ADR as part of your practice, in recommending it to clients, to other counsel, and how it actually has a lot of spin-off effects that are beneficial to your practice as a lawyer. There's still room for lawyers. You don't all want to be mediators. So if anybody wants a copy of that paper, just give me a call. So what I'm saying is this: we need you there, and it's very easy to walk out of a failed mediation and say, it didn't settle because of the mediator. Mediator was no good. The other opposing counsel wasn't going to settle. And what I'm suggesting is that we all look in the mirror, because I want to talk about some things that you can do to make sure that the process does settle. When we're at the table, each and every one of us has to make spur-of-the-moment decisions about, do we say this, do we do this? And what you choose to do as counsel sets a tone that is going to have an effect at the end. So if you, for example, say, no, I'm not going to show you that document, think about the ripple effect. The mediator is then scrambling to try to do some damage control around your refusal. You're not going to see it. And I was very interested when Linda said, watch the mediator to see the mediator's reactions. Believe me, I try hard not to react. But I've got going through my mind, oh my God, now what am I going to do? What you're going to hear me say instead is, well, I can appreciate that you don't want to show that document, but have you thought about this? And what I'm trying to do is build trust. So I'm constantly scrambling to react without looking like I'm reacting. So remember, the first thing I want to say is that whatever you choose to do, how you choose to conduct your case in the mediation, creates a pressure point further down the line. So think about that, please. Whatever you do is going to affect the direction of the mediation at some point. So you have to make a decision. Do you present your case, or do you let your client speak for him or herself? I would strongly urge you to let your client speak. It is cathartic, but more importantly, if we don't hear from the client, all we hear is the legal position, and that's not helpful. But it's your decision, and every decision you make is going to make a difference in the quality of the mediation. So how you brief your client when you're back at the office, what you tell your client is reasonable to expect, and how reasonable you can make your client, how much you reveal, how much you decide to keep secret. Big issue, huge issue. And you're going to hear me say, how does it serve your interest to keep that a secret? And you decide for yourself what you do. But these are all strategic decisions that you make. So I've got a handout, which is apparently available for you outside, and I've listed 6 or 7 things that you can do up front to make a difference. I just want to rip through these quickly. First of all, inform yourself about the theoretical underpinnings of dispute resolution. If you understand why dispute resolution works, you're in a better position to advise your client about the value of going. Mediation works for the following reasons. It's in all the very simple literature on dispute resolution, and it's worth reading because you'll do a much better job briefing your client. Second is, don't be adversarial. There's really no need for it in mediation. I described the physical layout. We go to real extremes to try to make your client feel comfortable. How your client feels is an important part of how far we can go in the process. And if you then come on like gangbusters, you are undoing a lot of the good work that we're trying to do. So do good advocacy, but you don't have to be adversarial to do it. This is not about being aggressive or doing positional bargaining. Third is understand power. And it's always interesting when I hear myself being described as a neutral. I'm not neutral. I'm impartial. I'm not neutral. I understand power. I know I've got it, and I can tell who's got it the moment you walk in the room. And I'm then trying to juggle power imbalances. I'll give you an example. A lawyer and defendant walked into the room, and they had power. They were wearing their $1,000 Giorgio Armani suits each, dripping in gold, big hair, seriously big hair. Plaintiff was a very small person of a visible minority with a lawyer on legal aid who wasn't saying very much. There was no power balance. And I was plaintiff had to settle. No choice, had to settle. And defendant was saying, I'm not going to give plaintiff anything. So in order to get any kind of a discussion going, I had to do something about the power imbalance. We did reach a settlement, which in my estimation, it's just an opinion, is about half what plaintiff would have gotten at trial, about half. Defendant was furious. And afterwards, defendant counsel took me aside privately and went up one side of me and down the other for not being neutral. I was neutral, I think, or impartial, because I think plaintiff should have gone to trial and gotten double plus costs. But what I was doing was balancing the power, and it may look like I'm not being neutral, but it's what I had to do. So that's about power. And if you understand it, you know what the dynamics in the room are, and you can be more helpful. I'm also asking, as my fourth point, that you be real, particularly in caucus. I can understand if you need to do a bit of posturing in the joint session, but when we go into caucus, would you please park it outside the door? That's where I need you to be giving your client real advice and talking truth to me. My fifth point is to ask you to forget about your need to be proven correct. Yes, I know you've researched the law. I know you know this point inside out. I know you want to tell me all of the cases that will persuade me that you're right and they're wrong, but I don't need to be persuaded of that. I don't make those decisions. If you want a definitive pronouncement that your point of view is valid, you need a judge, and that means a trial, and it may not be in your client's best interests. So if your client wants to settle, you may have to do it without an admission of liability. You may not get that precedent-setting case with your name on it. It just doesn't happen that way. We can't always settle the issues when we need to get a settlement. I'm also asking that you be tolerant of differences in style. Choice of mediator is a meaningful choice, and I support it. You don't get a choice at the ADR Center. You get whoever comes out of the chute. And I know that you like some mediators better than others, but would please note that it may be more a difference in style than substance. If all of the mediators know their stuff, we all come at it differently. So if you can put aside your preferences for style of mediator, I promise I will put aside my preferences for style of lawyer. my last point is to come prepared on both issues and settlement possibilities. We believe at the ADR Center that sometimes the mediations fail because the lawyers and their clients walk in without the slightest clue what it is they want and what their case is worth. They simply haven't addressed their minds to it. They're on a fact-finding mission. And this is not the setting for it. Please come prepared. Think about what you want and how you can accomplish it, and then come to be prepared to be surprised when everybody comes up with ways that are far more creative than you thought possible. So have an idea, but don't write it on the rock. So we don't have a screening process at the ADR Center. It's, we take whatever the last number of it's a very sophisticated screening process. Whatever the last number is determines who gets there and who doesn't. So perhaps who the mediator is has some impact, and the cause of action and what the case is about has some impact. Please remember, you have an important impact on the settlement possibilities as well. And if you've ever heard anybody say this settled in spite of the mediator, you'll know that what I'm saying is true. So again, there's another handout. Just from the top of my head, the one factor that we believe consistently makes a quality session happen is counsel attending with the following: the party with full knowledge of the facts, because storytelling is an important part of the dispute resolution ritual. The real decision makers are all in the room. Being there with a limitation is not being a real decision maker. The issues are well thought out, the briefing material is relevant and concise, the clients are well prepared, everyone has a realistic expectation, everyone has an open mind to creative possibilities, you have awareness of what your cost has been to date and your budget for trial, and you have a courteous and open attitude. And when that happens, so can the magic of mediation. Thank you.
Again, we'll take questions, but I'll start off with them to get the ideas rolling. I've done a number of mediations from all three sides, as mediator, as counsel for the employer, counsel for the employee. And I haven't had a mediation yet that hasn't hit a brick wall at some point in time. Usually I find about 2/3 of the way through. And what I'd be interested in finding out from this distinguished panel is how you get around those impasses. And I don't think it's necessary. I was going to create a hypothetical, but I don't think we have to. It's just, people have said that's my last offer, and the other one said I'm not going to move. How do you get off that impasse? Deborah, let's start with you. Give us.
There's a number of techniques, and they are techniques, but hopefully they're also part of my core being and how I am. It depends on what my assessment is, the reason for the impasse. So I don't have one technique, I've got a toolkit, and it's a constant evaluation of the dynamics in the room. And one of my techniques is to take counsel, who in that case was Barry Fisher, outside the room and say, here's how you can help me. This is what I need. And Barry came through for me. I took the other opposing counsel outside as well and said, look, we're at an impasse and this is my assessment of the reason why. And both of them went, yeah, you're right. I said, well, this is what's happening. What can we do about it? They were brilliant. So, what I'm saying is I do use counsel this way. You have an important role to play. Another way I have is, as Linda says, emotions are often getting in the way. I may call a timeout from the negotiating and go back and deal with first principles. Okay, let's go over your interests again. Let's talk about how you feel about this. Something's getting in the way and I don't know what it is, but I think I heard you say this. Tell me more about that. So those are two of many ways I use.
Okay, Linda, let me throw a hypothetical at you here. Let's put the impasse as your client. Your client is being accused of just cause, and the employer's made an offer, but the employer is insistent that the offer has to take into account the discount for the possibility it could win a just cause, and your client just can't face up to the fact that he has to take any discount whatsoever for what they consider a bogus issue of cause, and he's all worried about his reputation and everything. And you're in the room. This is about hour 9 in the mediation. What do you try to do other than twist his arm?
Well, first, you do twist his arm, but what you try to do is repackage it. Package it in a way that is palatable for your client. This happened to me specifically in a particular instance, and the discount wouldn't be accepted by the client, but we worked at repackaging this settlement in a way that was acceptable. Instead of, we knew that the employer wouldn't go beyond X amount of dollars in terms of what was reasonable pay in lieu of notice. And that X amount of dollars factored in a discount. But what we did was we looked at whether there was any outstanding pay in lieu of vacation time that wasn't taken that could be paid to the client. And the employer had a policy that if you didn't take your vacation, you lost it. But what we did was we came to the employer, we said, we understand that you want a discount, but we can't accept this lower amount. How about taking this vacation time that should have been lost and paying us something on account of that? And that was done, and we were able to package the overall settlement in a way that met my client's needs in terms of the dollar amount that was ultimately put in his pocket, and the employer's needs in terms of going back to the people in command and saying, look, we only paid X, being a lesser amount on account of pay in lieu of notice, to factor in what we think is cause.
Yeah, I think that's the one that I know we're involved in, so I know, and it's very important in these sort of things to understand what people's motives are. And having acted against a lot of employers and now for a lot of employers, you would be surprised how ultimately unimportant the dollar bottom line is to them. It's how it's packaged, it's how it's perceived, how they can sell it. Some employers will never pay bonuses. They'll pay excessive notice, but they won't pay bonuses. So you have to be sensitive to that. What do they care about? Now, Mark, you're in the same 9th hour here, and you've got an employer who has this lovely little severance formula that he paid some consultant to work out, and they've let go 500 people in the last 10 years. Nobody has ever contested their God-given formula, and this little jerk plaintiff is taking this case all the way to trial, and you know, as a lawyer, that this formula is well below reasonable notice. How do you get your client to move off his little formula and his idea that his whole career is going to fall in place and the floodgates are going to come if he gives this poor plaintiff a penny more?
I have no idea.
That's why Mark goes to trial.
No, let me just backtrack from that and just address it another way. I definitely in these things have lunch with my client or breakfast depending on what time of day we're going to have this little session, and we develop a want list in writing. And the want list is, where do you want to get by the end of today? Where do you want to get by the end of 2 years from now? And what's the money issue? What's the principal issue? What's the stumbling block to when somebody there says, I need another $2,500? All those things are vetted kind of ahead of time just because I've done this once in a while. If we get to a situation where my client is really skittish about settlement, I simply say to them, you don't have to settle. And I would think that would be a very bad policy if in fact nothing ever settled because I said that. But the fact of the matter is, reiterating to them that they are still in control of the process to me is very important for my client, because there was a comment made which tracks back to this idea of leave your ego at the door, leave your aggression at the door. I don't believe in that. I believe in leaving the ego at the door, true, but not the aggression, not the ability to profile that if this doesn't get done today, the other side, and especially the other side's client, may well get hammered in a cross-examination 2 years from now. I don't think you can just let that aspect go. So I'm very comfortable to say to my client at that point, don't have to settle. If we can't do it, we can't do it. It seems to me that the psychology in addressing that issue of still being free to negotiate or just walk turns itself around by after saying that, redeploying the issues of what it's all about. If it's $2,500 difference, I can easily tell them they're going to gobble up $2,500 in the next month. having this thing go ahead. If it's the issue of confidentiality, we can discuss in private with the assistance of the mediator the view of keeping it confidential with sanctions. I wouldn't just say we'll get them to sign a confidentiality agreement because it's not worth the paper it's on. But if it talks about making the person aware that the confidentiality agreement, if breached, costs money or has some sanction attached, then it works seemingly very well. But I believe that the mediators are the people who help in that situation. I'm not so sure it's the dynamic of the two lawyers who get us over those hurdles when they arise, Barry.
Any questions from the floor? Otherwise, I'll go ahead with another one. Yes.
I'd like to move the discussion outside of the center of the United for a second and talk about, looking at this from my perspective, which is Hamilton, we get to trial routinely within 12 to 18 months handily. We don't have excessive motions because we can't afford to squander our credibility with the local judges on silly motions. And I'm wondering if I should be missing this process, which, is there anything here really that I should be missing? I mean, it seems to me, given that 7% of the cases will settle before trial, there's a risk factor here of wasting a day and a half maybe with preparation in this process if it doesn't lead to settlement, where I know in 97% of the cases I won't have to take my claims to trial because the employer will see the light. I'm wondering, is this process preferable because of the conditions in Toronto, or is it preferable no matter where you are?
Could I answer that? Obviously, I can't. I'm going to tell a war story. Okay, this is war story alert. I obviously have to change some of the details because I'm bound by confidentiality as well. But here's an amalgam. Okay, this story is really a little bit from this case, a little bit from this case, but it's all true. The widow was suing her husband's employer for some benefits which the employer says the husband knew he didn't have, and she says, well, if he'd known that, he'd have told me. So clearly he didn't know that because I didn't know that, and he would have told me, so you have to pay. Had she gone to trial, she would have lost, probably. And it would have cost her money that she really didn't have. This was a long-term employee that the employer really cared about. But as soon as the lawsuit was instigated, employer got his backup wasn't going to pay just on principle, and that was important. Like every time you sue me, I should pay money. We came to mediation, and she cried and he cried, and they expressed their grief together about the loss of this employee. And he said, I still don't think I owe you anything, but I'd like to make you a gift because I feel so badly that you've lost your husband and you're now left destitute. And he wound up giving her a gift of money that was a reasonable settlement. Everybody agreed that she probably would have lost at trial. And she expressed in the session at the beginning how terrible she felt about the employer, how she felt that they had driven her husband to his death, worked him to death, made him feel terrible, et cetera, et cetera, et cetera. I mean, she was just giving them bad karma. And at the end, she thanked them very much and said that she knew that they really cared about her husband, and that's what was important to her. So we satisfied interests. Had they gone to trial, she would have taken the stand, spewed a litany of complaints about the employer, who would have had to stand up and spew a litany of complaints about him, and the judge may or may not have given anybody money. Nobody would have won. So we went from everybody losing to everybody winning.
But in fairness, the answer, may I?
Yep.
The answer to your question in the Toronto environment is that the employer lawyer gets a notice saying you're going to ADR. And it's 80, then 90, now fully 100% of employment cases are going.
It's a moving target.
Yeah, so in essence, it's not all that optional for the employer lawyer because then you have to get the consent of the employee lawyer saying, oh, look, I want to waive our rights to ADR. So inevitably you go because if you're the employer, you're literally told to go there.
But it still makes sense. It still makes sense to do mediation in any case, I think, before you even start litigation, although sometimes I think my habit is to start it too early and people have to be worn down a little bit. 97% of the cases settle, you're right, and the clients probably have absolutely nothing to do with it directly. We're all focused on what I call lawyer-based negotiations, which is what we've all been doing from day one. I think it's really useful to change the dynamics to what I call client-based negotiations. So the clients are involved in the process, they're there. And in fact, as a lawyer, its secret is it's almost easier. You're not making the decisions. Your job is to advise your client as to the parameters of a settlement. You could get between X and Y. You're not going to get below Y, and you're not going to get over X. Within that range, it's the luck of the draw, it's the judge, it's all that sort of stuff. My job is to get you to that range. Once the range is narrower, I'm taking a step back. You have to call the shots. It forces clients, both plaintiffs and defendants, to get involved in their own process. So I think you get a more satisfactory resolution as opposed to the 3 phone calls or the meeting over lunch with your Hamilton buddy. So I think the quality of the settlement is better. And even in Hamilton, mediation would be a good idea. I even did one in Aurelia. So if we can do it in Aurelia, you can do it in Hamilton. Yes?
Short comment and short criticism. It'd be nice if ADR could start before litigation. It can't be done unless the statement of defense or if you want to do before you've got a paperwork. And most plaintiffs can't afford that. So I realize you're stuck within a project and therefore you have certain limitations. That's just a comment I throw out.
How much do you think mediation costs? How much do you think a mediator costs?
I think I was quoted something like $1,500 per side.
That's very expensive. It's not that expensive. The costs are not anywhere near of a mediator what you're being quoted. It shouldn't be. Let's put it that way. Right.
No, but how much would it be?
500 to 1,000 gets you a good one.
Write that down.
I didn't. Shared.
Why can't ADR make a simple phone call to both counsel saying these are a number of dates that we have available, which dates can you both agree on, rather than just send a notice out saying you're coming on December 27th at 2 o'clock in the afternoon, and you've got to send this notice out to your clients, so you're wasting some of your clients' money, and then suddenly it gets rearranged later. Why can't a simple phone call be made to arrange a date?
The first comment you made is valid but very political, and so I'm going to dip my big toe into the political arena right here. I'm glad that you appreciate that the ADR Center is providing a free service, and it may not be for very much longer. I mean, just look at our political and economic climate. The project is at risk. We may or may not be given the funding to continue. We don't know. And if that's the case, we hope that you care enough about mediation to do exactly what the government wants you to do, which is take it into the marketplace. So if you're telling me that you won't use the private service providers because it's too expensive, that causes me some concern, because it may not be provided as part of the courts for very much longer. If you care about that, write a letter to whoever you think can influence the decision, because it's not ours to make. I appreciate what you're saying about the simple phone call, but it is not one phone call. It's 8 or 10 phone calls per file, and we're doing several hundred a month, and we don't have a person to spare who can just try to do what, I mean, think about the last time your secretary was on the phone for 3/4 of a day trying to set up one discovery. We can't do it. If it was one phone call to each saying, here's the date, and what we got back was, yeah, that date's great, fine, but it never works that way.
And I'm on the ADR user committee, and we spent a lot of time going over that, and they at one point had an 80% cancellation rate within 48 hours, and you can't run an organization that way. So rest assured that this procedure in terms of scheduling has been well thought out, and including representatives of the bar. It's not just a bunch of pointy-headed bureaucrats telling us what to do. Time for one more question. Janice.
I'd be interested in the comments from all of the panel on this, as most of the time, plaintiffs' counsel, not all the time, but mostly. And I've had a resistance to ADR, have been forced into it because I'm practicing in Laurel. But I've had a resistance because I've had a sense that I will inevitably end up with a compromise. And on those files where I think my client is almost sure of significant success, I don't want to be squeezed into the 50% position. And I'm talking about all kinds of ADR, both arbitration and mediation, that will inevitably with that sort of bias in me. I just like your responses. What do you say to plaintiff's counsel that has those sorts of concerns?
Well, you've hit on an interesting point, because I'm probably one of the few defense counsel in town who is constantly suggesting mediation and constantly getting refused by plaintiff counsel, which completely boggles me. But I've heard that before. I've heard that from both sides. And all I can say is, no disrespect, your ego's getting in the way. Your client doesn't give a flying whatever, whether they win 100% or not. Your client wants the issue resolved. Your employer client wants the issue resolved. They're in the widget business. They are not in the litigation business. So it's wake up. They're big people. Hopefully you're not representing children, and they can make decisions. And as Mark said, they don't want to settle, they won't settle. But maybe when they get there, they don't want to go through 2 years of litigation because they're going to win a little bit more. Maybe they're much happier to take 60 cents in the dollar and get on with their lives.
Maybe, that's not.
That's the client call, though. And I say it's the client call, it's not the, so if your client says, no, I will never settle, I don't care, first of all, I'd ask for an extra large retainer. Second of all, it's not my input at all. I give advice, client gives instructions. That's how I deal with it.
Could I make 2 comments? It's not always the case that it's at the 50% level.
Mm-hmm.
Sometimes the solutions are so creative and so novel that you would never have thought of them. You're in the litigation mindset, which is there's only money at stake here, and that's just not real. Sometimes we come up with solutions that are so innovative they surprised me, and you think you've seen it all, you haven't. The other comment I want to make is one that was made to me by a plaintiff who was afraid to accept the settlement. She said, but my mother still works for the company, and I'm afraid that they'll be vindictive because they have to pay me. And I said, well, if you'd gone to trial, there'd be something for them to be vindictive about, because a judge is ordering them to pay when they don't want to. But they're here. They're offering it voluntarily. This is about healing, not revenge. You're getting something a judge can't give you, which is them extending a hand of friendship and saying, yeah, we see that you're right, and this is what we want to do, and let's put it behind us and get on with our lives.
May I, though, play devil's advocate and say that there is an awful compression of the whole case into 4 hours, with a tremendous amount of pressure put on the persons in the room to get it done by 4 p.m. So I think it's fair to be world wary about going into the process with that in mind. That's not a negative aspect on it, but I think it's healthy to remember that there are artificial constraints being created to get it off the books, and so that there can be an achievement of settlement. As you know, I sponsor the process because I think it works, and I think everybody ends up the better for it. But I don't think we should let down our guards. That your question is a good one, that, should we be conscious of what we're doing, which is compressing 2 years of litigation and fact-finding and evidence gathering and everything else into 3 hours of extraneous issues, sometimes extraneous factors.
That's Toronto-centric again. That's at the ADR Center. For those of
No,
you who don't know, it's a 3-hour session, and Mark says 4 because we're not bureaucrats. If you need 4 hours, we just go without lunch. And we do that quite routinely. But in my private mediation practice, I'll set aside 8 or 9 or 10 or 12 hours.
Understood.
For the same reasonable rate, of course.
And also,
The day rate includes the night rate.
That's right. There's no overtime.
What are the costs again?
Well,
Total cost be, if you're quoting a client very modest means, saying, look, I think we can settle this, why don't we bring a mediator in? You were saying that the costs you were quoting were split?
the usual rule is that the parties agree to split the cost of the mediator. That's the rule going in. Now, as an employer, I shouldn't be telling you this, but if I really want mediation, and you're playing games with a lousy $300, I'll offer to pay the whole thing because I believe so much in the process. Ultimately, as plaintiff's counsel, the last thing that you throw in is, and you'll pay the whole mediator, won't you? Yeah, fine. So it may end up costing your client nothing, but there's no way you should seriously consider, your costs of going to mediation are going to be a hell of a lot more than the half you're going to be paying the mediator. So the cost factor, to be fair, is the prep and attendance. The actual payment to the mediator can be relatively modest. And I know that there's very good mediators who will work for $1,000 or less a day.
and even, if I may, just one last point, even with respect to the compressed time frame for mediation, there's no requirement that you settle within that compressed time frame. If the settlement that's being put on the table is uneconomic, isn't palatable, you can walk away. And that doesn't mean that the mediation is a failure, because what happens often is the client that walks away starts thinking about settlement options, is in a settlement mode, has heard the other side's perspective, understands better what the other side's interests and needs are, is able to better identify his or her own interests and needs, and starts to think about creative resolution. So even if the number that's put on the table is half of what you might get if you end up at trial, you walk away. But that doesn't mean that all efforts were for naught.
And at the, just remember that mediation is not it doesn't exhaust the field of dispute resolution. We offer other things as well, so that if you can't settle in the 3 or 4 hours, you can come back. If we're making progress, we can offer you a neutral evaluation by a judge. I mean, there's other things we can do. Mediation is only one point on the dispute resolution continuum. And if any of you are curious, Mark did not hurt himself at the ADR Center. I've beaten up on him in the past, but not this time.
Thank you very much, panel. That was very helpful on mediation. Now we'll take as much time as it takes to change seats. Now you're going to hear about arbitration. The other side of the ADR set.
Thanks, Mark.
Thanks, Mark. Okay. Since Deborah got you involved in an interactive mode, how many of you have appeared on an arbitration? Less, I thought so. Okay. Let me just talk for a minute about what arbitration is and what it's not. It is not mediation, okay? It is not touchy-feely coming together with your inner child, reaching out and all those other lovely terms we learned, which is all perfectly valid. It is a trial. It is a trial by, however, a difference. You don't bow and scrape to the person. The person is anyone you want to be the arbitrator. It is a consensual process. The two parties agree who the arbitrator is. It may or may not be a lawyer. It may or may not be someone who's ever done an arbitration before. It may be someone who you simply respect their integrity and their expertise in the area. So arbitration is, by its nature, and in this field at least, I can safely say 100% consensual. The parties can never force you into the process. Having agreed on the arbitrator, it is very, very much like a trial, in the sense that it is a binding decision of the arbitrator. In fact, the arbitrator's ruling decision is more binding than a court, because in all likelihood, and I'll go over it in a minute, you have contracted out of the right of appeal. And therefore, the only avenue of redress open to the aggrieved losing party is judicial review. And the test for setting aside an arbitrator's award is what the courts call patently unreasonable, what I call the out to lunch test. So that's what arbitration is. It is a trial with a hired judge of your choice. Okay. We have a little different today. I'm putting in this panel, I'm not going to be the moderator. I'm speaking as the arbitrator. I'll give you the arbitrator's perspective. We have two distinguished counsel. They don't get the joke because they weren't here when I made it earlier. Again, we're doing the Mutt and Jeff routine. I'm not sure which one's the Mutt. George Vassos is a partner at the law firm of Harrison Partners, one of the leading, not the largest, because that belongs to somebody else, but one of Canada's leading employment law firms. And George, although he represents both sides, is here today taking the plaintiff's point of view. And representing the employer, we have Paul Jarvis, who at the firm of Hicks Morley wouldn't know what an employee, only knows employees, as sitting on the other side of the table. Paul's firm is exclusively, as far as I understand, representing management, and Paul has extensive experience in the labor arbitration field, primarily in the labor arbitration with trade unions, but he's speaking today as an employer in a wrongful dismissal case because the similarities are very close. I guess I'll deliver my paper first, if that's okay with you guys. I'm the high-tech one with that little diskette. How many of you have computers? Good. Let me just talk. The same agreement, the paper and the agreement are in the book, and this is just the agreement. It's copyright-free, shareware, freeware, junkware, whatever you want to call it. It's in two formats: Microsoft Word and WordPerfect DOS, which you may know as WordPerfect 5.1. And if you don't know, ask the person who sits outside in front of that terminal. He or she should know. It's also, if you have another format, as long as it's not a Commodore or something ancient like that, call me and I can get it to you in a different format. Okay, one of the arbitration is consensual, as I said. And therefore, you have to agree on certain things before you get into the arbitration process itself. The act that legislates, or that governs arbitrations in this area is not the Labor Relations Act, okay? The Labor Relations Act only covers arbitrations involving trade unions and their employers. And this is a private consensual arbitration. It is under the Arbitration Act. And Paul Jarvis's paper very nicely sets forth the framework of the Arbitrations Act. In essence, the Arbitration Act determines certain issues cannot be contracted out of, but they are very few and far between. Things like the arbitrator can't be a biased SOB. He may turn out to be that, but you can't contract to allow the arbitrator to be that way. After that, a few other technical provisions, it's up to the parties to decide what they want in the arbitration agreement. Now, knowing that most lawyers don't even have a clue as to what the issues are, the Act is designed so as to create, in a computer techie term, default provisions. Unless you agree to something else, the Act prescribes X. One example is, unless you say otherwise, you're talking about a single arbitrator, not a board of three. However, most of those provisions can be contracted out of. So what's necessary in doing an arbitration is to have an arbitration agreement. And when I first started trying to push arbitration onto the wrongful dismissal world, I realized that one of the main reasons people were starting lawsuits was because it was easy. Because everybody had a statement of claim in their computer, everyone could flip to whatever the texts were, or go to the senior partner and get a copy of the statement of claim, and you didn't have to reinvent the wheel. So I decided to try to invent the wheel so that arbitration would be easier. So I sat down and I came up with this arbitration agreement. And I designed it with a certain number of premises in mind. That the user would be someone who's probably never done an arbitration before. Probably because people who do arbitrations all the time would never choose it when they had to. No. So I wanted to make it very user-friendly. So rather than reinvent all the rules that apply to arbitration, I simply incorporated the rules of civil procedure, the rules of practice, whatever the rules of civil procedure, into the arbitration agreement, so that where a reference is made to the rules in the arbitration agreement, it incorporates by reference the rules of civil procedure. So that was one aspect. The other aspect was I wanted to make people understand that this was a flexible process, that there was choice and there was option. So when I designed the agreement, it's like a shopping list. Do you want beans with pork? Do you want beans with tomato? Do you not want beans? It's prepared in that context. So please do not just fill out the whole document and sign it, because it will be absolutely useless. It's designed to give you alternatives. And what I thought I would do briefly is my part of the presentation, considering I only have about 7 minutes left, is to briefly go through and raise with you the types of issues that you need to resolve to come to an agreement on what's in the arbitration agreement. And if you could turn to page H3 of the paper, it's the second to last paper in the, well, it's H, so. And what I've done here is I've produced the agreement with some minor commentary underneath. Page 1 is basically just incorporates the rules of civil procedure. On page H4, I talk about issues in dispute, and here's where you can get creative, especially as an employer counsel. You're faced with a plaintiff's lawsuit where they're alleging every exotic cow claim known to man, inducing breach of this, all this. The tort guys go crazy. Somebody writes an article about it, and the next day, every claim all of a sudden is included. I think the flavor of the week is breach of the obligation of fair dealing or something like that. So you get one of these claims. You know in your mind this is really just a notice case. And but you're a little scared because who knows, there actually may be some mental distress floating out there. So you as employer counsel want to get rid of that stuff. Well, that's the price of going to arbitration, you say to the plaintiff. I'm prepared to arbitrate. I'm prepared to give you a resolution in 6 months rather than 26 months, but I don't want to have to deal with all this other stuff. So I'm only going to agree to arbitration if we agree that the issues are 1, 2, 3. So you can be creative on that idea. The next is accepted facts and law. You may have agreed between the two of you that certain issues of certainly facts and even law will not be open to discussion. And the example I've used here is either party agrees not to rely on the doctrines of near cause or ballpark justice. For whatever reason, I just made those up, for whatever reason, each side may have a fear that the other side might use a certain legal doctrine, and they'll say, well, okay, I won't allege ballpark justice, but I don't want to hear out of your lips inducing breach of contract. So we'll both agree that that's off the table, or the court can't take that into account. You couldn't do that in a trial. Your Honor, that's not the law. We've agreed it's this. They wouldn't go far. Arbitrators, hey, you're paying us, we'll do virtually whatever you want us to do. If you want us to not apply the doctrine in your cause, we won't. Selecting an arbitrator. This is the critical issue. The two main reasons, in my opinion, and the other parties will indicate why, from their perspective, they want arbitration, is you want somebody who wasn't practicing real estate law until he was appointed to the bench and just can't wait to get his fingers on a wrongful dismissal, but he doesn't know what it is. And you want to avoid that judge you had the other time who hates you. You may feel the same way that he or she feels about you, and you don't feel you're going to get a fair hearing. And you have better things to do in your life than calling Mr. Sams and wondering when your trial is going to be, if it's going to be, and putting your entire practice on hold. So you have the ability in an arbitration to choose the arbitrator, who can be anybody you want. Okay? I've given in the paper, I'm assuming you'll want somebody with some expertise. In the paper, I've given you a list of 3 authorities that you can check with to read biographies of arbitrators and choose one. The other main power of an arbitrator is either you or the arbitrator can set the dates of the hearing. Now, what a luxury to know that your case will start March 21st, 1996, and then will proceed again on April 2nd, 3rd, and 4th, because you are going on vacation. You don't have to deal with anyone. That's part of the agreement. So you sit back. It's a much more restful practice, having an arbitration practice, than a traditional litigation practice. You can agree on the location of the arbitration hearing. That may be an issue. One party may be in Toronto, the other party may be in Vancouver, and you agree on Winnipeg? No. You agree on Hawaii to do the hearing. Employer pays costs, of course. Pleadings, you can agree to have them, not have them, whatever you want. Documents, you can agree that the same rules of civil procedure apply. You can agree forget the affidavits. Both parties just will exchange documents. Or you can go trial by ambush, which is what labor arbitrations tend to be. No document production. I do not suggest that. The rules of civil procedure are good in document production, so I encourage you to incorporate that. If, God forbid, you have any of these motions and intermatters, and by the way, it's not just lawyers in Hamilton who think motions are a waste of time. A lot of Toronto lawyers do too. You can give the power to the arbitrator to do it. But you don't have to send some student to hang out at 145 all day. You can pick up the phone and do a telephone motion if you want. Examinations for discovery, you can have them or not have them. I like them, so I would have them. And one of the big things that's the huge difference between this type of arbitration and a labor arbitration, where there is no discoveries at all. You can contract in to have discoveries, And I happen to think as a lawyer that they're pretty valuable, so I would always ask for them. Evidence at the arbitration hearing. There's a myth out there that arbitrators don't really apply the laws of evidence. What the reality is a labor arbitrator has a different set of standards for evidence, and on some specific rules it may be a little bit lighter, hearsay especially, but the hearsay rules have moved considerably over the years in any event. But you can tell the arbitrator that he or she will apply the laws of evidence as if they were a judge. So you tell them that. Or you'd say, nah, you can act like a labor arbitrator, or you can act like a labor arbitrator, but we really hate this rule, so you won't apply it. And you tell the arbitrator all those things. So you can do that in terms of evidence. The remedial powers of the arbitrator, you can add or subtract to those powers. You can empower the arbitrator with more power than a trial judge would have, the power of reinstatement. I can't imagine why an employer would ever agree to that, but it's theoretically possible. Or you can subtract powers away. You shall not have the right to award punitive damages. You shall only have the right to award damages of these categories. All those things you can do in an arbitration agreement. You can apply the offer to settle rule. I happen to think it's a very good rule, so I stick it in when I act as counsel on these things. Reasons for the arbitrator, you can ask the arbitrator not to give reasons. You can just say yay, nay, or as George talks about, you can have a final offer selection process where the arbitrator is not determining the amount, but is forced to choose between the two offers. This is what happens in baseball arbitrations. I would suggest that you do want brief written reasons from the arbitrator. I find as an arbitrator that the process of writing the arbitration award increases the quality of the award itself. It forces you to think it through. So I wouldn't jump, although it looks encouraging to say I don't want written reasons. I'd force the arbitrator to do it. Unless, of course, your case is really lousy and you're only going to win on emotion, and the last thing in the world you want the arbitrator to do is actually think about it, then maybe you will want reasons. Award of costs, you can empower the arbitrator to award costs. You can take that power away from him or her. The usual rule, the rule under the Act is that each side pays half of the arbitrator's fees. Now, what I said about modest mediators' fees doesn't apply. Arbitrators do tend to charge more. You're looking probably at a low of $1,500 to a high of about, I don't know, I'm not the high end, $3,500 a day. I think that's probably about tops. But there is a bonus involved. Mediators, remember, walk away at the end of the day, close their briefcases and go home. Arbitrators have to go home and write the award. And in Ontario, when an arbitrator quotes a block fee of a daily rate, that includes writing the award. So if he or she quotes you a $2,000 one-day rate and the case takes 1 day of evidence, whatever writing time is included in that $2,000. So that's something to keep account of. There's incidental fees, of course, in getting facilities. If it's not being done in someone's boardroom, those costs can be whatever a hotel cost is. If you're in, it can be $150 to $250 a day. Now, the fees of the arbitrator must be borne by each side, but you can empower the arbitrator with the power to order one side to indemnify the other. So in effect, you can give the power to the arbitrator to award full costs, complete full costs to one side. Transcripts, I don't think you need them because there's probably no right of appeal, so you save that. But if for some reason you want to have a transcript, you can do it. And the rights of appeal, as I say, you can contract out of it at various levels. And a very important aspect from an employer point of view, you can contract that the entire process is confidential. So this is a very useful thing, I think probably more for the employer, and Paul will talk about that, but I've always wondered why a company firing their vice president of finance for cause on the allegation that he's ripped off the company for 10 years, whether they really win that case when the Globe and Mail reports, Smith Corporation succeeds in firing corrupt CFO. I'm not sure I'd want to win that case. So confidentiality allows both parties to litigate and bring out their dirty laundry in private. The bottom line is the arbitration agreement is what you and the other lawyer make it. You can fashion the litigation process to fit your needs, not 145 Queen Street's needs. And I think that's a very valuable tool, and I encourage you all to use it. Now we will hear from Mr. Vassos first as to why an employee would want arbitration, the pros and cons, and maybe a little bit on how he would conduct an arbitration perhaps differently than a trial. George?
Thank you. Good day, everyone. I venture to say that the arbitration of wrongful dismissal cases is truly the final frontier. I suspect there probably aren't too many counsel in this room that have actually conducted an arbitration of a wrongful dismissal claim. And this whole area is very much in its infancy, and I think you can tell that when you, for example, look at my paper, and as you read through it, there are very, very few references to cases, because this is all brand new and we're all sort of figuring it out as we go along. Now, obviously, most lawyers in this field tend to look at the labor arbitration model as a good model upon which to conduct an arbitration of a wrongful dismissal case. And that is the starting point for most counsel. During the mediation session that we just went through, hearing those speakers, we heard some comments about how a lot of plaintiffs stress how important the principle involved is. And when I act for plaintiffs, I do hear that from some plaintiffs, but more often than not, I hear from plaintiffs who say, look, I'd like to get as much money as I can, as fast as I can. So anything you can do to help me in those objectives, I will appreciate you for the rest of my life. And to the extent that you have a plaintiff employee who's focusing on the time element and the money element, arbitration has some attractive advantages over litigation, at least on the surface, and we can talk a little bit today about how far these advantages really actually take us at the end of the day. Now, I've identified, I think, probably at least 6 areas in which there are potential advantages to a plaintiff employee who now wants to arbitrate a wrongful dismissal claim. The first of these, and important to many, many employees, is the question of cost savings. Obviously, as a general proposition, companies are in a much better position to conduct costly litigation as compared to an individual employee who is now obviously out of work, unemployed, and probably their only source of income at this point is unemployment insurance. So costs are a very, very important concern for an employee. And I guess I put you as a general proposition that the cost of arbitration will likely be less than the cost of litigation. Now, that doesn't apply in absolutely every case, and there are a number of factors that you really do need to look at. At first blush, it's not all that easy to assess this area until you've had some experience in it. And part of the problem is that there are some unique costs to the arbitration process that don't appear in the litigation process. First and foremost, and the greatest cost, is the cost of the arbitrator that you will retain. And as Barry mentioned, the range can be anywhere from about $1,500 to $3,500 per day, normally split between the parties. Obviously, the longer the hearing, the greater that cost is going to be, and probably the less incentive for a plaintiff employee to get involved in that process. The more complex the case, the longer it takes, the bigger that cost. Also, in terms of unique costs, we have the reporter's fees if a reporter is present, the costs of preparing an arbitration agreement, and room rental, if that's an issue, and of course applicable taxes on top of all of that. But in its simplest form, if you're going to do an arbitration of a wrongful dismissal claim, in its simplest form, you simply agree, you simply set out the parameters within the arbitration agreement, you pick your date, and you show up at the arbitration someday. And what you've done away with, obviously, in terms of the normal litigation process, is everything from affidavits of documents to preparing for discovery, attending at discovery, attending at pretrial, preparing for pretrial. You're eliminating all of those traditional steps in the litigation process. And for those of us in Toronto that are also involved in the mandatory ADR process, you're eliminating that as well by if you simply agree to go to arbitration in lieu of litigation. So what you're really juggling when you're looking at costs, on the one hand, you're looking at what are the unique costs of arbitration, and on the other hand, you're asking yourself the question, how much can we save by not going through the traditional steps of litigation? Now, Barry, as he went through his draft agreement, his model agreement, he stressed that you can pick and choose. You can take whatever features of the civil litigation process you want to and incorporate it into the arbitration model. Obviously, the more features you incorporate from litigation, the less you're going to save on costs at the end of the day. So costs are very, very important. I think those of us who've had experience at labor arbitration know that labor arbitrations tend to take a bit more time than a comparable matter would in court. And that's simply because at labor arbitration, there is no discovery in advance. There is no exchange of documents in advance. You, in most cases, simply show up and conduct the case. And arbitrators, and maybe Barry can speak to this, but my experience is arbitrators in general are fairly flexible when it comes time to have counsel say, could we please have a few minutes to review these documents before we proceed any further with the matter? Arbitrators generally bend over backwards to accommodate parties when they need to take instruction. And that tends to lengthen the process. So that's an important consideration to keep in mind. The second area I think that is particularly attractive for employees is the question of selecting the arbitrator. There really is an inherent appeal in being able to pick your own judge to look at your case at the end of the day. That's a very, very attractive feature. And in selecting the arbitrator, there's also one very important advantage related to the question of knowing the business. If you're in court, you never know who you're going to draw as a judge. Obviously, when you pick your arbitrator, you know exactly who you're going to get. And if you've got a situation, for example, if you're dealing with an engineering company that's dismissed an engineer because of alleged non-performance, it would, I think, do a world of good to have someone as an arbitrator who's not only skilled as an arbitrator, but also perhaps has an engineering background. If you get into that kind of a situation, that tends to shorten the process. It may well eliminate the need for experts' reports because you've got someone who understands the business. I myself was involved in a situation where, in the film industry, where there was a dispute between a production company and a director, and they had started litigation. They ended up shifting over to arbitration, and the person they picked as their arbitrator was someone who had a very lengthy career in the film industry, both as a director and a producer. And that person was an ideal candidate because he had had experience on both sides of the fence. And I guess it goes back to Barry's point, you get to pick exactly who you want. And that's a very, very important feature of this process. The third advantage for an employee is the question of an expedited process. This is perhaps more of an issue here in Toronto, where the delays are generally 2 to 3 years between the time you start your litigation and the time you end up in court. It's perhaps less of a concern outside Toronto, where the lists tend to be a bit shorter. The issue that comes up in terms of the expedited nature of the process, however, is the question of, well, what happens if we conduct the hearing before the expiry of the notice period? Now, that happens on occasion when you go to court and you get into issues involving whether or not a judge should impose a trust on any earnings that an employee may have during the notice period. In the arbitration process, you get to pick your date, and a very, very reasonable request, in my view, on behalf of an employer, is to have the arbitration conducted after the notice period that's going to be claimed. So if it's a 12-month notice period, conduct your arbitration in the 13th, 14th, 15th month, and then you know exactly what's happened with mitigation for that employee during that period. And I think an employee will, generally speaking, agree to that type of a proposition to accommodate the hearing after the notice period. The fourth area of advantage for an employee is the question of convenient timing. And what often happens is, by the time these things come up for hearing, an employee will have secured another job, and it tends to be difficult to get away for a court matter when you don't know exactly when the court matter is going to start. We all know that confirmed dates in court really are no guarantee of anything. Until that day comes, you don't know whether there's a judge available or there isn't a judge available, and that creates a real problem for a plaintiff who has now taken on new employment elsewhere and is trying to, in effect, to a large extent, sneak away for a few days so they can fit in this little piece of litigation while they're at new employment. My experience is that employees will often try and structure these things on defined vacation periods, and obviously convenient timing becomes a very important consideration. Confidentiality, I agree with Barry's general assessment that that tends to be more of a concern for employers, but it can be just as great a concern for employees. As an example, there are many, many more cases now in the sexual harassment area, and once you get into those cases, you're often into obviously very personal types of information, and it's often just as important for an employee to have confidentiality as it is for the employer. There is a recent case involving the Calvin Klein Company, wrongful dismissal matter which made the courts, where one of the factual allegations was the question of whether or not the employee had a body odor problem. That to me is not the kind of case where if I'm plaintiff's counsel, I would want that in court and splashed over the pages of the newspaper. That's the kind of case I think I'd make a very strong attempt to get into arbitration behind closed doors. If you act for parties in a family dispute, I guess the McCain family dispute is a good example. If you act for professional people, if you act for high-profile individuals, confidentiality becomes much more of a concern. The sixth area where I think there's some advantage to an employee is in the area of informality. I think for those of us that practice on the plaintiff side, we've all had employees who have said to us, look, I want to start a lawsuit, but there's no way I want to go to court. I want to try and force a settlement if I can, but I just don't want to go to court. I'm afraid to go to court. And it's surprising how often we do hear that. Arbitration, very informal. You sit across a table, witnesses are sworn, so there is that formal element to it. But beyond that, it's a very, very relaxed kind of atmosphere when you sit down in a hotel conference room or a boardroom somewhere to deal with the issues at hand. And that informality, I think, should not go unnoticed on the plaintiff side. It's usually much more of a concern on the plaintiff side than it is on the corporate employer side. Those, generally speaking, are the areas of advantage that I see for employees. But you can't just focus on these perceived advantages. You really do have to put this in context. And there were some comments made, I think, earlier on with respect to the question of how often wrongful dismissal cases do settle. And I was canvassing members of my firm and other lawyers practicing in the field before I got here. The lowest number I've heard from anyone in terms of settlement rates for wrongful dismissal matters is 95%. And I've heard estimates going right up to 99.9%. So the odds of settling a wrongful dismissal case in the litigation process are very, very high. And you have to recognize that up front, and you have to say to yourself, well, do I want arbitration where in effect I'm gearing up for a hearing process when the odds are very, very high that through the litigation process this will settle? Now, we all know that these cases settle at different points. They don't all settle immediately after the claim is issued. Some of them do settle on the very doorstep of the court. So this is a very practical concern, and you really have to factor that into the mix when it comes time to determine whether or not you think arbitration is appropriate. From where I sit, I think that there are probably two circumstances in which arbitration will be most likely used. The first one is where cause is not an issue, and the only issue is either length of the notice period, mitigation of damages, or both. I think there's a very good use for arbitration in those cases. And secondly, cases where the parties seem convinced right from the outset that there really is very, very little chance of the case settling, and it's going to take a judicial determination either in court or through an arbitrator to give us the answer to the problem. And if the parties, in effect, recognize that up front, there's another case where arbitration is more likely. The more complex the case gets, the longer it takes, in my view, the less likely the parties are going to end up in arbitration, particularly so because of the arbitrator's costs associated with the process. Now, I'll finish on this note, and that is Barry raised the question of final offer selection, and I have to footnote him. Barry and I have been discussing a case which we're going to put to arbitration. Barry and I are counsel on the matter, and one of the things we've discussed is final offer selection. It was Barry's idea, so I have to footnote him in that regard. Very simple concept, and I think it would work well if the issue is only on the question of what length of notice is appropriate. We all know that judges deal with ranges when they deal with notice periods. And final offer selection is a very simple process, most often used in the baseball context. The ball player says, I think I'm worth $5 million, and the baseball club says, well, we think you're worth $1 million. Those two positions are then tabled before the arbitrator. The parties attend the hearing, and each party makes arguments with respect to why their number is more appropriate than the other number. I see a real use for that in the wrongful dismissal context if the only issues are length of notice period and perhaps mitigation of damages as well. It certainly causes the arbitrator to focus, and what it prevents the arbitrator from doing is splitting the loaf. And I think those of us that have been to court on wrongful dismissal matters, we all know the process. Plaintiff counsel comes in with the high cases, employer counsel comes in with the low cases on notice periods, and guess what? The judge often splits the difference between those cases, unless of course they're dealing with Barry Fisher's database, and then you're clearly focused on what the averages are. So I think final offer selection is a great alternative in this area. It's a very, very simple way to deal with a narrow issue. Subject to questions later on, that's what I think is important from a plaintiff's perspective.
We're going to go a little bit longer, and I'm sure you'll all stick around. I guess my only comment on George's comments were this thought that if you don't choose an arbitrator unless you think it's going to go all the way, I'm not sure why, because you can choose arbitration, and most arbitrators have a cancellation fee that over 30 days they charge you nothing or next to nothing. So contrary to what George says, I think you could look at arbitration as the first alternative. If it settles, and you won't incur that added expense. Or if there is a cancellation fee, it's quite modest, and that's something you ask the arbitrator. What are your cancellation policies? And the arbitrator will tell you that. Okay, next and last, in terms of formal speakers, we're going to hear from Paul Jarvis now, from the employer point of view.
I can be very brief because Barry and George have both really very well outlined for you the arbitration process. And I think that the message about arbitration is that it can be what you want it to be. You very much create the vehicle in the way that you want it to be. I find 5 factors particularly attractive about it, but that's frankly just personal experience, and I'm sure that there are others who have other priorities. I find probably the most attractive feature to it is the ability to decide who your decision maker will be. For me, that leads to any number of positive results. If I can know who my decision maker is going to be, I don't need an appeal process. If I can know who my decision maker is going to be, I know that my client's going to be content at the end of the day because they're going to have had the hearing that they wanted to have, win or lose. It's an absolutely huge factor that we see on the labor side of things that to me transfers 100% to the wrongful dismissal context. The second factor that I see that makes arbitration attractive is the ability to set the dates. It's not just a personal convenience, although goodness knows it is a huge personal convenience. It enables appropriate preparation. It enables witnesses to plan their lives. These are factors that are meaningful both to plaintiff and defendant. Perhaps defendants tend to have more witnesses than plaintiffs in cases. In any event, that certainty is a real negative feature for clients in my experience, and a real positive feature to the arbitration process. The third factor, these aren't in order because perhaps it's the least significant of the 3, but I too see a real benefit to the informality, to the setting, that arbitration takes place in. One of the provisions of the statute itself is that arbitrators can't mediate or conciliate during the process, and I take slight disagreement with Barry's comment. There remains at arbitration, just as there does at trial, some de facto mediation. And there is nothing more positive for the parties than to find out midway or earlier during the arbitration process, if they've had to go that far, from the decision maker that they've chosen and respect, that the case looks like it's going this way or that way. So I would invite you to think about retaining that kind of informality, not just in the setting, but in how your arbitrator is going to hear your case, and leaving that ability to do a little mediation, whether you do it by waiver or whether you make that a power in the arbitrator right from the start in your arbitration agreement. Fourth factor, confidentiality. I don't know your experience, but anyone who settles a wrongful for me, with me, does it on the basis of the matter being dismissed on consent without cost, because it's very important to my clients not to have some kind of record. They're prepared to pay the money, but they don't want to set the precedent. The ability to have that also at the hearing phase would be very attractive to the employer, and as George has pointed out, can be very attractive to the employee as well. And finally, arbitration can give you the finality that Barry identified. And I go back to, if I've got the decision maker that I have confidence in, I'm quite prepared to accept that finality and not have to reserve to myself the right of appeal. My paper deals with the statute that you're left with. There are certain elements of the statute that you can't contract out of. There are most elements of the statute that you can. I'm not going to take you through it, because the message from the paper is you have to read the statute before you draft your agreement, because you're going to be making different choices about what you want to be there as the fail-safe, what you want to be in your agreement. So I simply recommend that anyone who's considering this immediately go to the statute. And I guess the final comment that I'd make is to endorse the concept of final offer selection again. It's a concept that preceded baseball. It's actually a concept that comes from the labor field and has been around for 30 or 40 years, although it hasn't been largely used. And frankly, wrongful dismissal couldn't be a more perfect place to use final offer selection. And I say that because when you hear the example of baseball and the $1 million and the $5 million, there's an element of unreality to that. And the parties, I mean, $1 million sounds pretty good. In the context of wrongful dismissal, where you're talking about the difference between $25,000 and $50,000, or $50,000 and $75,000, there is real pressure on the parties to put forward their very best offer when they know that the arbitrator is going to choose as between those two figures. And the reality in collective bargaining in the labor field is that final offer selection, where parties have the nerve to invoke it, leads to settlements, or leads to choices for arbitrators between two positions that the parties can live either one with. And in the wrongful context, where you're paying for that arbitrator, you're likely to be able to reach that final settlement rather than having the interest arbitrator impose it, as happens in labor law. So I think that final offer selection deserves serious consideration by anyone who's willing to go the arbitration route, because I think you may find that it leads to there not being an arbitration at the end of the day, that the positions will be so close that there's a resolution. And the final point that I'd make, I think I agree with Barry. My experience is that there are different pressure points that lead to settlement. There's the canvassing at the outset for the reasonable settlement if you can find it. There's the reality check that comes as the trial approaches. Well, that reality check is there in arbitration. And in my experience, a third to half of the labor arbitrations that I do settle at the point of the hearing, because that's when the witnesses get real. That's when the lawyers get real to some extent. And that's when the theories are going to have to actually be played out, and just how do you feel about them. Why not accept that reality and use an arbitration process that gets you to that final decision point within 3 to 6 months instead of within 2 to 3 years. I throw it out as a question, but I see that as being an advantage of the process as well.
Thank you very much, Paul. Any questions from the, I have no prepared questions because I gave a paper. Any questions on arbitration, or do we all want to go to lunch? Looks like we all want to go to lunch. Thank you very much. I hope this allows you to incorporate some new ideas into your practice, and good luck. Thank you.